Welcome to the deep dive. Okay, today we are strapping in for an exploration of one of the most foundational pieces of law in the modern economy. And frankly, maybe one of the most complicated too, the Labor Relations Act of 1995, the LRA.
That's right. It's absolutely central.
Yeah, it really is the centerpiece of industrial relations.
Mm-hmm.
It shapes how millions of people negotiate their workday, their pay, their rights. It's huge.
It is huge.
But our mission today is to try and, well, cut through some of that legal complexity. We want to distill the essential rights, maybe some surprising organizational power structures, and definitely the practical takeaways you really need to understand.
And you're right about the complexity, but also it's not static. That's key. While it kicked off in late 96, the LRA is, a living thing. It's been amended quite a bit in response to economic changes, social shifts.
Like those big ones in 2002, 2014, 2018.
Exactly. So it governs everything from, disputes right there on the shop floor all the way up to industry-wide bargaining. It's broad.
So let's start right at the beginning. Why? Why was this act even created? What's the core idea, the philosophy behind all this detail?
Well, Chapter I lays it out pretty clearly right up front. It's got these 4 interwoven goals: advancing economic development, ensuring social justice, maintaining labor peace, and importantly, fostering the democratization of the workplace.
Democratization of the workplace.
Yeah.
Interesting phrase.
It is, and it's explicitly linked to the Constitution, Section 23 specifically, which guarantees fair labor practices and the right to organize. So it's fundamentally a rights-based framework designed to, manage conflict.
Manage conflict. So the LRA basically accepts that, look, conflict between employers and employees, capital and labor, whatever you want to call it, it's inevitable.
Yes.
But it provides a very strict kind of legal sandbox for that conflict to play out in.
Okay, so if that's the big picture goal, how does the Act actually start building this structure? What are the very first rights it lays down? That takes us straight into Chapter 2, freedom of association. And what's really interesting here is the duality of it. The Act doesn't just give rights to workers.
Ah, okay.
It gives employees the right to form and join trade unions, sure, but it equally gives employers the right to form and join employers' organizations. It's about enabling collective power, on both sides of the fence.
Right, leveling the playing field in a way. But look, the right to join a union doesn't mean much if your boss can just punish you for doing it. So where does the law draw that protective line?
Oh, that line is drawn very clearly and very strictly. The LRA gives these general protections saying no one, employer or employee representative, can discriminate against someone for exercising any right under the Act.
Hey, sure, that's broad.
Yeah, it is. And it starts right from the job interview. An employer can't legally ask someone applying for a job to promise not to join a union. And they can't force a current employee to give up their membership either. That's the shield, really, for genuine freedom of association.
Okay, the shield. And speaking of protecting rights, what about the burden of proof? This is often where things get tricky, right? If I say I was fired for union activity, who has to prove what?
Yeah, this is crucial. The rule is sort of designed to make sure claims aren't just baseless, but also to protect the worker. The law says the person alleging the problem, usually the employee or the union, has to first show the basic facts of what happened.
Okay, establish the act itself.
Exactly. Once they've done that, the burden shifts entirely. It flips over to the employer. The employer then has to prove that what they did not infringe the act. They need to provide a solid, non-discriminatory reason for their actions.
So it sounds like a filter for weak claims, but also make sure the employer can't just hide behind some vague excuse if union activity was actually the reason.
Precisely. It demands transparency when these fundamental rights are potentially in play.
Okay, so the right to organize is established and protected. Now, we move from that individual right to, collective power. That's Chapter 3, right? This is where the LRA gives organizations some real teeth.
Absolutely. These are the organizational rights that unions, specifically representative trade unions, need to actually function effectively inside a workplace. One of the big ones is the right to elect trade union representatives, or TU reps.
And that's not just pick whoever you want. There's a structure.
Oh yeah, there's a formula. It's based on how many members the union has at that specific workplace.
Walk us through that. How does it scale?
So if a union is representative, meaning it has enough support and has at least 10 members there, they can elect reps. It starts small, 1 rep if they have 10 members. Then it scales up, 2 reps for 10 to 50 members, and it keeps going up to a maximum of 20 reps if the union represents over 1,000 employees at that site.
20 reps. Wow. And these reps, they're not just like symbolic figures. They have actual jobs to do. Definitely not symbolic. They have key functions spelled out, helping employees in disciplinary hearings or grievance procedures, keeping an eye on whether the employer is following labor laws. And here's a big one. They get reasonable time off with pay for training and to actually do their union duties. The with pay part. That's massive, isn't it? It makes it a recognized role, not just something you do in your spare time.
It absolutely legitimizes the role within the workplace structure. Okay, so you've got protected rights, elected reps. Let's talk about what comes out of this collective power. Collective agreements. This sounds like where things get really transformative for individual employees. They really are transformative because legally they stand above your individual employment contract. A collective agreement isn't just, a guideline. It legally binds the parties who signed it, their members, and the law says it explicitly varies any individual contract of employment covered by its scope.
Varies it, meaning changes it.
Changes it. So, if you personally agreed to, say, 10 days of sick leave in your contract, but then the union negotiates a collective agreement that mandates 15 days for everyone in your category, you get 15. The collective agreement overrides your individual deal. Okay, that's serious power. And this is also where we find some of the, let's say, more controversial tools in the LRA toolbox, the agency shop and the closed shop agreements. What are these and why are they so potent?
Right. So the agency shop deals with what people call the free rider problem. If a union represents the majority of employees covered by an agreement, non-members in that same group can be required to pay an agency fee.
So they benefit from the union's bargaining, maybe better wages or conditions, so they have to chip in for the costs.
Exactly. They contribute financially even if they don't join as full members. Now, the closed shop, that goes a big step further.
How so?
A closed shop agreement requires all employees covered by it to actually be members of the designated union. It's incredibly powerful for the union, giving it huge stability and bargaining clout. But surely that's restricted. You can't just force everyone. Oh, it's heavily restricted. It needs massive support. It has to be approved by a 2/3 majority in a secret ballot of all the employees who would be covered. And crucially, there's a protection. If an employee refuses to join based on a genuine conscientious objection, like for religious or deeply held ethical reasons, they cannot be dismissed for that refusal. So there's an out for conscience. Do they still pay anything?
Usually, yes. They often have to agree to pay an amount equivalent to the union dues to an agreed-upon charity or fund instead, so they don't get a completely free ride, but their conscience is respected.
Okay, moving up a level now, from a single workplace to potentially whole industries.
Yeah.
The LRA sets up bargaining councils. These sound important. Are they just talk shops?
Definitely not talk shops. Think of them more as instruments for setting industry standards, maybe even economic standardization across a sector. They're established jointly by unions and employers' organizations.
Covering what? Like engineering or construction nationwide?
Could be nationwide, could be regional. Often sector-specific, yes, like engineering, clothing, motor industry, you name it. Their powers include resolving disputes across the whole industry, setting up central training funds, managing things like pension or medical aid funds for the sector.
Okay, managing funds, resolving disputes. But I hear the really big power, the one that gets debated, is their ability to extend their agreements to companies that aren't members of the council. How does that work?
That's Section 32, and yes, it's significant. It means the agreements they reach, minimum wages, working conditions, things like that, don't just apply to the companies and union members directly involved in the council. If the council is deemed sufficiently representative of the sector.
Sufficiently representative.
Yes.
Meaning it covers a large enough portion of employers and employees.
Exactly. If it meets that threshold, the minister can extend the agreement to bind all employers and employees in that sector and geographical area, even the non-unionized ones, even those who didn't participate in the negotiation.
Wow, so you could be running a small non-union shop and suddenly find you have to pay the same wages as the big players negotiated at the council.
Potentially, yes. The rationale is to prevent a race to the bottom, to stop companies competing solely by undercutting labor costs. It creates a level playing field on basic conditions and helps stabilize the industry. But yes, it's a powerful mechanism, staggering power, really. Okay, let's pivot. What happens when the talking stops, when dialogue fails? Chapter 4. Strikes and lockouts. The ultimate leverage. But you can't just walk out, right? What makes industrial action protected? No, you can't just walk out if you want legal protection. It's all about following the procedure. The Act lays out a strict checklist for a strike or a lockout to be protected, meaning the participants generally can't be dismissed just for taking part. The underlying dispute must first have been referred for conciliation.
Conciliation like mediation. Trying to find a resolution first.
Yes, usually at the CCMA or a bargaining council. And that conciliation attempt must have failed, or a set time period must have passed. Only after that, and after giving proper written notice, usually 48 hours notice, can the protected strike or lockout begin.
Process, process, process. Are there jobs or sectors where this right to strike, even following the process, is just off the table?
Yes, absolutely. For public safety and order reasons. The right is limited if the service is designated as an essential service.
And the Act actually names some.
It does. It specifically deems the Parliamentary Service and the South African Police Service, SAPS, as essential. There's a committee that can designate others too, like emergency health services, air traffic control, things like that. If workers in these essential services have a dispute over wages or conditions,
No strike.
no protected strike, they are prohibited from striking. Instead, their disputes must be referred directly to compulsory arbitration for a final decision.
So they trade the power of collective action, the picket line, for the power of legal argument in front of an arbitrator. That's a fundamental shift in leverage.
It is. It maintains vital services, but removes that ultimate industrial pressure point. And this need for process and arbitration naturally leads us to the structures needed to manage all this, the institutions of labor justice under Chapter 7.
Right. Let's talk about the CCMA. It feels like the absolute engine room of the LRA in practice.
It really is. The CCMA, the Commission for Conciliation, Mediation and Arbitration, is central. The Act stresses its independence. Its main job, its first step, is conciliation, trying to resolve the vast majority of disputes quickly, informally, usually within 30 days.
And if that doesn't work?
If conciliation fails, then for many types of disputes, it moves to arbitration. The CCMA arbitrator then acts like an informal judge, hears evidence, and makes a binding decision. The CCMA also has other roles, like stepping in with advisory arbitration panels during really long, damaging national strikes.
Okay, so CCMA handles the bulk. But for the really big, legally complex stuff or appeals, we have specialized courts.
Correct. You have the Labor Court, LC, and then the Labor Appeal Court, LAC. These are superior courts, like the High Court, but they have specific, exclusive power over LRA matters. You generally can't take an LRA dispute to the regular High Court.
What kind of things end up in the labor court?
Serious unfair dismissal claims, especially automatically unfair ones, disputes about protected strikes, urgent applications to stop unprotected strikes, and very importantly, reviews of CCMA arbitration awards.
Reviews. So you can challenge a CCMA decision.
Yes, but not easily. You can't just appeal because you don't like the outcome. You have to argue there was a specific legal defect in the arbitration process itself, like the arbitrator misconducted themselves or made an unreasonable decision. The labor court acts as a check on the quality and legality of CCMA arbitrations. And the LAC is the final appeal body for labor law. Okay, that makes sense. Let's shift focus now, maybe zoom in on the individual employee's ultimate safety net. Chapter 8 on dismissals. You mentioned earlier the employer has a really high bar to clear here.
Incredibly high, yes. The LRA basically starts from the premise that a dismissal is unfair unless the employer can prove two distinct things. First, that the reason for the dismissal was fair, and the Act limits fair reasons to the employee's conduct, their capacity, or the employer's operational requirements, retrenchments.
Okay, reason first. What's the second? Second, they must prove that the procedure they followed leading up to the dismissal was also fair. Did they investigate properly? Did they give the employee a chance to respond? The entire burden, the onus of proof for both the fairness of the reason and the fairness of the procedure, rests squarely on the employer.
The employer has to prove both. And what about those dismissals that are just completely forbidden? The automatically unfair ones.
Yes, Section 187. These are the absolute no-go areas. If an employer dismisses an employee because they took part in a protected strike, or because the employee is pregnant or intends to get pregnant, or for any discriminatory reason, race, gender, sexual orientation, religion, political opinion, you name it, that dismissal is automatically unfair.
Meaning the employer can't even try to argue it was fair for some other reason.
Basically, no. The law deems those reasons fundamentally illegitimate grounds for dismissal. The penalties and compensation can also be much higher in these cases.
And if a dismissal is found unfair, whether automatically unfair or just regular unfair, what's the usual remedy? Does the CCMA or labor court just order the employer to pay money?
That's a common misconception. No, money isn't the first prize. The primary remedy, the default starting point under the LRA, is actually reinstatement.
Putting the person back in their job.
Exactly. Putting them back in the job they lost, as if they were never dismissed, maybe with back pay. Reemployment in another suitable position is also an option. This is always the remedy the arbitrator or judge must consider first.
Unless
Circumstances make it genuinely impossible or completely inappropriate. For example, if the trust relationship is utterly destroyed and cannot be repaired, or if the job genuinely no longer exists, or if it's just not reasonably practicable for the employer to take them back. Only then does compensation become the main remedy, usually capped at 12 or 24 months' salary, depending on the type of unfair dismissal.
reinstatement first. That's a really important point. Okay, finally, let's touch on the modern workforce. The LRA has been amended to deal more specifically with non-standard work, right? Things like labor brokers and fixed-term contracts.
Yes, Chapter 9 and related sections were beefed up significantly, particularly by the 2014 amendments, to provide better protection, especially for lower paid or more vulnerable workers in these arrangements.
So temporary employment services, TES, labor brokers.
Right.
How does the law handle that three-way relationship now? Who's liable if things go wrong?
Okay, the TES is technically the statutory employer. They issue the contract, pay the wages, but, and this is critical, the law now says the TES and the client company where the employee actually works are jointly and severally liable.
Jointly and severally,
Meaning if the TES, the labor broker, fails to pay the worker what they're legally owed under a collective agreement or the Basic Conditions of Employment Act, the worker can pursue either the TES or the client company or both to get their money. The client can't just wash their hands of it anymore. They're on the hook, too.
That gives the worker much more security. And isn't there specific protection for lower-earning workers placed by TES?
Yes, this is a big one, Section 190AA. If an employee placed by a TES earns below a certain amount, there is an official earnings threshold that gets updated then after working for that client for more than 3 months.
3 months. What happens then?
They are legally deemed to be the employee of the client company for the purposes of the LRA, not the TES anymore, but the client. And from that point on, the client must treat that worker no less favorably than their own permanent employees doing the same or similar work. Same pay, same benefits, same conditions.
Wow, after just 3 months, they effectively become integrated into the client's workforce in terms of rights and conditions if they're below that earnings threshold. That's a major shift.
It's designed to prevent the indefinite use of lower-paid brokered labor to undercut permanent staff conditions.
Does a similar principle apply to fixed-term contracts? Can employers just keep rolling people over on short contracts forever?
Not easily anymore, again, especially for those earning below the threshold. Section 198B says that if an employee is on a fixed-term contract for longer than 3 months, that contract is generally presumed to be of indefinite duration, essentially permanent.
Presumed permanent after 3 months. Unless
the employer can show a proper, justifiable reason for the limited duration. And the Act lists acceptable reasons, like hiring someone specifically for seasonal work, or to work only on a particular defined project with a clear end date, or to replace another employee who is temporarily absent, like on maternity leave.
So you need a genuine objective reason for the fixed term, not just convenience or avoiding permanent employment obligations.
Exactly. It stops the abuse of fixed-term contracts to create perpetual temporary status for jobs that are actually ongoing.
Okay, so if we just, step back and look at the whole picture we've painted, the LRA is clearly way more than just a rule book for hiring and firing.
Oh, absolutely. It's this incredibly complex, dynamic legal framework that tries to structure and regulate the entire relationship between employers and employees, both individually and collectively.
From the huge sector-wide bargaining council agreements setting wages for thousands, right down to the nitty-gritty procedural fairness needed before dismissing one single employee.
Precisely. And I think its real genius, if you can call it that, lies not just in the rights it grants, but in mandating these robust institutions, the CCMA, the councils, the specialized courts. These structures are designed to divert conflict away from immediate power plays, away from costly court battles or disruptive strikes, and channel it towards dialogue, conciliation, mediation, and structured arbitration first.
It's a framework trying to balance constitutional rights with the need for, labor peace and economic stability.
That's the constant balancing act, yes. Which brings us to our final thought for you, the listener, to perhaps mull over. Given everything we've discussed, the detailed requirements for collective agreements, the mandatory procedures for fairness, the disclosures, the power given to unions and councils to standardize conditions across competitors, the LRA doesn't just regulate labor. It effectively imposes a specific, quite demanding standard of organizational democracy and enforced transparency on almost every business. So the question is, what's the true long-term economic and societal effect, benefit, or perhaps cost of building workplace relationships, not just on, say, goodwill or informal trust, but primarily on these formal legally enforced mechanisms and this mandated procedural transparency? Something to think about.